Hello and welcome to today's webinar, What Families Need to Know About Planning for a Loved One with Special Needs, presented by Elville and Associates Managing Principal and Lead Attorney Stephen Elville. My name is Jeff Stauffer, Community Relations Director with Elville and Associates, and I'll be moderating today's event. So how this will work today, if you're new to our webinars, if you are, welcome. We're glad you're here. If you're coming back to see us again, thank you for being here as well. So you as the attendee are currently in listen-only mode. However, if and when you have questions, please note them in the questions panel on the right-hand portion of your screen, and we'll take plenty of time to address them throughout the presentation as well as at the end. Your questions really help the presentation and add a lot of value. They help others learn. So please don't be shy in posing your questions at any time to Steve, and I'll be sure to pass them along to him. You also received the presentation yesterday by email from me to take notes on it if you wish. If for some reason you did not receive the presentation yesterday, it is available in the section marked handouts in the panel on your screen to download at this time. And as always, for our CFPs, CPAs, and various other professionals, welcome. On today's webinar, you may receive 1.5 continuing education hours for attending. So per my attendance records requirements, please email me your board ID. And also for CFPs only, I also must have the last 4 digits of your social security number as soon as possible so I can submit your CE hours for approval. Everyone will also receive a post-webinar feedback email right after the presentation, and we ask that you please just take a couple minutes to fill out the simple survey to offer us your feedback about today's presentation. It's also an ideal time to request a consultation with Steve for any planning needs that your family and you may have now or in the future. And as always, we look forward to being a resource to you here at Elville and Associates. So briefly, as we have a lot to cover, I'd like to offer you an overview about Elville and Associates and share a little bit about Steve. And then we have a lot of new people on our webinar today, so welcome to everybody, wherever you found us out there on the internet or through an invitation that we sent to you. So I'm gonna show my screen here, there we go. So Elville and Associates, we were founded in 2010 in Columbia by Managing Principal and Lead Attorney Stephen Elville. We have a number of practice areas that we offer here at Elville and Associates, including estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, tax planning and asset protection as well. We have 7 attorneys, 12 staff members in 5 locations. We're coming to you live from the Columbia Gateway community location here in the heart of Columbia right now. We have our mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, education, and superior legal technical knowledge. And we do focus on education here at Elville and Associates, as many of you know. And we do that in several ways. Through our planning processes with our clients. We also offer over 100 educational webinars and workshops in the communities that we serve each year, and also by way of our accredited client care program, or CCP as we call it. We're one of only 2 firms in the state of Maryland to have an accredited CCP by the Client Care Academy in Boston. We also work with the ideals of client education, collaboration, and compassion in mind with every client every day. A little bit about Steve. If I can get to the screen, there we go. So Steve's work as an attorney for the past 20 years, 22 to be exact, has been centered in elder law, special needs planning, and estate planning with an emphasis in areas of tax planning and asset protection. A member of many different national membership organizations, including the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, and the National Network of Estate Planning Attorneys. He works to bring peace of mind to clients by creating solutions to their needs through counseling, client education, and the use of leading-edge legal technical knowledge. A very seasoned speaker presenting at many webinars, workshops for businesses and their employees, conferences, and continuing education events each year. Also named to the Maryland Super Lawyers list for a 7th time in 2022, so congratulations to Steve. And also had a feature story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, which is our firm's charitable organization he founded in 2014, and I'm privileged to be the executive director of. So if you'd like to learn more about the Elville Center and how we work to make a musical difference in the lives of children each day, please reach out to me and I'll be happy to share our story with you at another time. So with all that being said, let's get into the presentation. But before we do, let's learn a little bit about you. We have a brief poll to learn what's brought you to today's webinar. And the poll is, to get to know our audience, please tell us what has brought you to today's webinar. And the choices are, 1, I need to set up planning for a loved one with special needs. 2, I have planning in place, but it needs to be revisited, which is not out of the ordinary. 3, I'm a financial advisor here to learn to benefit my clients. Or 4, I'm an interested family member here to gather information. So please just make the choice that best suits your situation so we can get to know you a little bit. And then Steve will get started. Okay, and with most of the responses collected, we have 17% saying I need to set up planning for a loved one with special needs, 17% saying I have planning in place but it needs to be revisited, 22% say I'm a financial advisor here to learn and benefit my clients, and 44% say I'm a family member here to gather information. So welcome to everybody. Appreciate you being here. Steve, I'm going to go ahead and make you the presenter.
Thank you, Jeff.
You should see that button pop up on your screen. There we go.
And I'm going to minimize your screen. And you should be able to see mine. I'm going to go to the slide stuff. And if that looks good, I'll go ahead and start. All right, well, good morning, everyone, and thank you, Jeff. And June greetings to everyone. I can't believe it's already June 22nd. Welcome, and thank you for spending your time, your very valuable time with us on this day. And we're going to spend about the next hour and a half learning and drilling into the basics of special needs planning. And I want to thank Jeff, who is my longtime colleague and friend who facilitates these webinars. Without Jeff, I could not do what I do, along with everyone here at Elville and Associates and all my mentors who helped me in my education and my progress as an attorney. So it's only because of them that I'm able to be here with you today and share the basis of my experience with you and what I would call is a mini master class on special needs planning. I don't expect that you're going to remember all of it, but I want you to be able to take away substantive information, maybe 4 or 5 bullet points that you could walk away from this today and know that you probably know more than about 95% of people know about special needs planning. We also want to facilitate not only just the education that we're committed to here at Elville and Associates, but we also want to facilitate a path for you to get documents updated, to be able to get new documents in place, to be able to learn and your family members to learn and to become educated. And that's what actually makes estate planning, special needs planning, elder law planning, whatever the case may be, that's what actually makes it work. So welcome, welcome parents, relatives, advisors, clients, the general public, welcome to our webinar. All right, well, it's June and I know many of you are very busy, so I'm going to get right into the information. I wish you a happy summer. Jeff is getting ready to go on vacation, so congratulations, Jeff. And for all of you that are vacationing and enjoying the summer, we wish you all the very best. All right, so I'm going to get right into the information. Please know that as I do, as Jeff alluded to, Jeff is an expert moderator. He will take questions. He will stop me occasionally. I'll take breaks occasionally. We're going to see what you have to say and do our very best to give general information for your education. We are not allowed to render legal advice in these types of webinars, and you can't take any of this as legal advice, but this is general client or potential client public education. All right, with that said, we're going to keep going. And Let's first start with why special needs planning is so important and why make that plan. Well, the whole idea since the inception of special needs planning is really to enhance the quality of a person's life, the person with disabilities. And thank goodness with supported decision making now becoming the law in Maryland, which many of you have heard about, many of you have anticipated. We're going to talk a little bit about that today. Enhancing the quality of life of a person is a combination process. It's a collaborative process. But with regard to the special needs planning itself, the idea is to maximize the quality of life for a person, to achieve your goals in the planning. Remember that all planning is goal driven, whether you're a parent, a sibling of a person with disabilities, a grandparent, whatever the case may be, we want to help your loved one reach their potential and to be able to, under supported decision making, have as much self-determination as absolutely possible. So we're going to talk more about that subject in a minute of supported decision making. Now, the benefits of planning are self-evident for most of you, but these are just a list of some of the things. We want to provide financial security going into the future. This is one of the biggest questions client families have. How can I provide security for my loved one with special needs? We want to understand and utilize the means-tested benefits that are available. Now, this is a general rule of thumb. This is not going to be true for every person. There are people of wealth who plan for special needs and who do not rely on the public benefit system, but the vast majority of people are going to want to leverage public benefits, means-tested benefits, and they're going to want to use that as part of the future planning for their loved one. Having a team of advisors, having a proper CPA, having a proper financial advisor who you have confidence in, that's part of this process. And maybe an advocate, someone who is a life care manager who's going to provide advocacy for your loved one. This is the team that we want to put in place. So if you don't have that team right now, you're not alone. Many special needs families do not have this team in place. We want to help you have that team in place, and kudos to the financial advisors and CPAs who may be on this webinar learning more about special needs planning, because one of the things we find in practice is that there's not enough financial advisors who understand special needs planning and can really relate to parents. Many of you have housing on your minds. How am I going to provide the right housing for my loved one, the appropriate housing? So that's a big topic. And again, I mentioned advocacy and an advocate, caregiving, planning for an entire extended family situation. Many of you have more than one child or loved ones who are willing to help or who are part of your team to support your loved one with disabilities, and we want to coordinate with that entire family plan. And in some cases, we're not using family members. We're going to be using non-family members. So we want to do all that coordination. Protecting beneficiaries from predators and creditors and fraud and abuse. All of those things absolutely are part of special needs planning. And then for some of you, a lot of you are going to be concerned about preserving assets for your other children or beneficiaries. We want to provide for financial security for our loved one with disabilities, but we also don't want to forget that, God forbid, if they were to pass away, that those assets would be properly distributed to our other family members, and for most cases, avoid a payback to the state of Maryland. So that's a lot. That's a lot to talk about there in that slide, and we'll just keep going. So as we go through this, many of you are going to see that I'm repeating myself, and that's intentional. Jeff and I call this intentional redundancy. So we want to make sure that we're driving home the education that you are most, in our opinion, the most in need of. So I'm talking here again about having the right team of advisors. We're going to strongly recommend that in estate planning and in special needs planning in general, we want to have a team of advisors. None of your advisors today, no financial advisor, no lawyer, no CPA, none of those people really know it all. The world is very complex. We want to make sure that you have a team. Now, that's not always easy to do, to assemble that team, but it's ideal. So I want to give you the ideas today about what you would want to achieve the highest and best planning. We want to plan for flexibility. Now, are we living in a very changing world, which I just mentioned? The answer is yes. Despite all of those things that are going around, all around us, COVID-19, whatever the future holds with regard to healthcare and health issues, political issues, overseas issues, all of these forces, these economic forces as well, we want to make sure that we have flexibility in the plan. So your special needs plan, however it's constructed, which we're going to talk about, that plan, in my opinion, needs to have the flexibility to deal with the future situations. And I know most of you would agree with that. So we want to have an advisory team. We want to have advocates. And part of the flexibility is something called the trust protector. Maryland calls this a trust advisor, but nationally, this is known as a trust protector. This is a special fiduciary who can play a role in a special needs trust, can also play a role in your will or trust. And this is a person who can make changes to the documents, can make sure that the trustees are doing what they're supposed to do, or even remove and replace trustees. These are the kinds of issues that most parents, most grandparents, most loved ones are going to want to consider for flexibility in the future. It's not absolutely required, but we think it's essential for special needs planning. So let's talk about creating the effective plan that we're leading up to. Well, what's one of the biggest things that you can do? Well, if we just stopped right here, which we're not going to, but if we did, you can see that there's a ton of things to talk about before we even really get into the substantive material. So you want to have time to think. You want to do the very thing that we find most special needs parents and loved ones do not have, and that is time. Time to really think, not to mention the time to really think about the options that are available and the details and the education for loved ones so that they'll know what to do when you're no longer here. That's one of the biggest things that ever since even before COVID-19, we here at Elville and Associates think that giving clients time to think, coming into our conference room and thinking about where will your loved one live? What type of level of care will be required? Do they need a guardian or conservator, or can they avoid that with the new supported decision-making law that's going to be effective October 1st, 2022? What other considerations have you not thought about? What kind of lifestyle is desired? Are we going to really fund a special needs trust with a tremendous amount of money from life insurance or other sources? Or is this going to be a more restricted trust because of the assets that we are able to provide, and we want to make those assets last as long as possible? What are challenges that we are either thinking about or haven't thought about? Building layers of security, layers of trustees, layers of trust protectors, layers of advocates, layers of protection, and really understanding your process and purpose. So we at Elville and Associates are going to provide the process. We're going to provide the education, but we can't provide your purpose. You have to have that purpose, and we know you do. It just is that we want to give you time to think about and refine what your purpose really is in coordination with your team of advisors. Now, along those lines of thinking about what your intentions are and what your purpose is, here we want to use one of the most important things that I could share with you today, and that is a memorandum of intent. So if I were to do something silly like sit here in my office and stack up a bunch of documents, and let's say I had 1,000 wills, 1,000 trusts, 1,000 special needs trusts, my question to you is, would they all look the same, or would they look different in a very general sense? Well, the answer is they would all look very similar in some ways. And where I'm going here, even though I'm being very facetious, I want you to think about your special needs plan, your trust, your will, and your special needs trust for your child or loved one. I want you to think about that as being very customized and very personal. And the only way to do that really is to use a memorandum of intent. Some people would call this a letter of wishes, and this gets attached to the back of the trust or the will. And what this does is it tells about your loved one, their needs, their physicians, their wishes, their eccentricities, their issues in life, and their healthcare history, and what you want for them and how you want the trust administered for them. This is arguably the most important thing in the entire plan. And it represents a lot of work. So I know that this is a lot that I'm talking about here, but I know that you've devoted your whole life to taking care of your loved ones. So this is not going to be anything hard for you. It just is going to take time. So we want to provide that to you. Jeff is going to be sending you out a sample. You don't have to use my sample, but a sample memorandum of intent if you would like to see it. And we encourage you to use this as a guide. Why? Well, I want you to think about it this way. If you were to die and it was 5 or 10 years after your death, and someone who is not someone you thought, not someone you had planned for, not someone that you anticipated would be your trustee or your advocate, somebody new because of changed circumstances, something has happened. This person, the only thing they have to know about your loved one is this memorandum. I want you to think about it like that, because when you create that memorandum like that, with that in mind, you're going to create a very powerful document that will describe what your loved one needs and what your wants and desires are for them and what their personal information is, even if the trustee doesn't know your loved one at that point in time. So arguably, again, this is the most important thing. I want you to focus on this, if nothing else today, a memorandum of intent. Now, financially, many of you are concerned about, well, how will I fund a special needs trust? So we want to do things like estimations of income and expenses. Now, I am not a financial advisor, but I've been very fortunate to work with many, many financial advisors over the years, and some of them are our best friends and supporters here at Elville and Associates and referral partners, and we can help you meet one or to interview several if you would like to meet a financial advisor. But my point of this slide is to encourage you to use the resources available to financial advisors and use those to your benefit. So I want you to think in terms of how much is going to be needed in the future. Very simply put, we only know about what we have today. So we are who we are a certain age, we have a certain financial picture, and we just don't know how much we're going to have when we pass away many years from now. So what you can do is project and use the resources of financial advisors to try to figure out, how will I fund the special needs trust? And maybe the answer is going to be life insurance. So this is going to be a huge issue. Should I purchase permanent life insurance or other insurance to fund the trust? But my point of this slide is to encourage you to use the financial advisor's resources. Some of them, of course, are much more sophisticated than what I'm showing you here. But the idea here is we want to be thinking about, how will we leave money to the trust and not just take a chance on having X amount of dollars at the time of our deaths. Okay, so that's what we want to think about financially. Now, one of the highest and best forms of planning in special needs is to also address the incapacity issues for the person with disability. So now we're not talking about you, we're talking about the loved one with disabilities and whether or not they can sign powers of attorney and advance directives as people with legal capacity. Now, of course, if they do not have the mental legal capacity to sign documents, we will not have them sign documents in any event, but this is a counseling issue. It's also a case-by-case issue. Does my loved one need guardianship? Well, we know guardianship is the highest form of intervention. It takes away someone's legal rights. And fortunately, in Maryland now, the whole paradigm of guardianship has shifted right before our very eyes. And we are putting out a new newsletter today or tomorrow. And one of the articles is the one I wrote on. It's the lead article on supported decision making. So if you go down to the bottom of this slide, we see that a supported decision maker could be appointed after October 1st in Maryland. And what this means is that people with disabilities will no longer have only two choices. Can I sign a financial power of attorney and advance directive? Or if not, there's no middle ground, and all of a sudden the only option is guardianship. So now we have this wonderful middle of the road option called the appointment of a supported decision maker, or supported decision making. So supported decision making sounds complicated, but it's actually very simple. It basically says that if I'm a disabled person, a person with disabilities, I am deemed by the state of Maryland and many other states now, but the state of Maryland says I can make my own decisions to whatever extent possible, provided that I have the support to do so. So if I have the support to do so, which Maryland now says it is willing to recognize that, I can, if I'm disabled, I can appoint someone to be my decision maker, my supporting decision maker. They cannot make decisions for me, but they can help me make my own decisions. They have no authority to make my decisions for me, but they are to support me in making my decisions. And when you have a chance to really let that sink in, this is the huge, huge paradigm shift that many of us have been waiting for. Most of you have been waiting for this, where your loved one can have a financial power of attorney and advance directive if they have legal capacity. What does that mean? That means that if they cannot make their own decisions because they're incapacitated, they have an agent who can make those decisions. What does supported decision making mean? Supported decision making means that to whatever extent possible, they will make their own decisions, but they have this financial power of attorney and advance directive as a backup if they can't make their decisions at all because of incapacity. Now, for those of you who have loved ones under guardianship, this is going to be good news and excellent news, actually. And if you're considering guardianship, it's going to be excellent as well. The new law provides that even if a person has a guardianship, they are a ward under guardianship, they can still be deemed to be able to make appoint, I should say, a supported decision maker. So a person can be under guardianship under the new law and still have a supported decision maker. So this is a huge day, a brand new day for people with disabilities, as far as they're being able to have their own greater what we call right of self-determination. And at a recent conference where we were speaking for the Brain Injury Association, one person who was there, who was actually under guardianship, understood what we were saying here, and he said in front of everyone, this is a good start. And I thought that was just about saying it all. This is a good start. It's a big decision for the state of Maryland. It's a great thing for people with disabilities. And as we think about special needs planning, we don't want to forget about addressing the needs of the person with disabilities for future decision making with supported decision making in mind. Jeff, I'm going to stop just for no other reason than to get a drink, see if we have any questions.
Well, thanks, Steve. No questions as of yet, but thank you for stopping.
All right. Let's now delve into something that many of you are living with every day, and you may or may not understand fully what you're dealing with public benefits. Notice that this is critical for trustees to know about. Most trustees do not understand public benefits, so this is a tool I'm going to suggest before we get into this material that you read a book or two about this, or that you purchase a book for your trustee to read so that they understand the fundamentals. And one of those good books, among many, is written by a gentleman named Kevin Urbash, U-R-B-A-T-S-C-H, Kevin Urbash of San Francisco, California. And his book is called How to Administer the California Special Needs Trust. How to Administer the California Special Needs Trust. Don't worry about the California part, because the book is universal in its application, and it's easy to read, even though it's thick. And this is going to be a basis for a good understanding of public benefits, among other things about special needs planning. I would highly recommend you purchase that book off of Amazon or some other source. Let's break down public benefits into three categories, and I'm Sorry to use the word categories, but this is the best way to think of it. From left to right, let's look at the column that says SSI. This is the quintessential means-tested public benefits program. Basically, many of you are aware of this already. Your child, having turned 18, receives SSI, and as a result, they receive over $800 a month, and that is the full SSI award, Supplemental Security Income. That is a means-tested benefit because your child cannot, or your loved one cannot have more than $2,000 in their name. Sad but true, but it is a very big rule that we know we have to deal with. And as a result of that, your child or loved one receives Medicaid. In Maryland, we call that medical assistance. Now, going to the far right side, we see Section 8 benefits, veterans benefits. I'm not going to dwell a lot on this today, but let's just say that HUD benefits, government benefits for housing, are difficult. They're difficult to deal with because every distribution from a special needs trust to or for the benefit of the beneficiary is going to increase the rent of a person who is in HUD housing. So if your loved one is in HUD housing or you're considering HUD housing, don't worry about it too much, but you need to be aware that the distributions from a special needs trust can affect rent. We're not going to focus the rent amount or the rent going up. We're not going to focus on that today. We're going to focus on the other two columns. So let's go back to the left now. The SSI or Supplemental Security Income column, that is the quintessential definition of disability, okay? And that is what we want to guard against. If we have this quintessential situation, the trustee of a special needs trust is going to want to make sure that they do not inadvertently disqualify a beneficiary by distributing money directly to them, making them overscale, which means they have more than $2,000 in their name and so forth. That's pretty obvious, but that is something that is a very big problem. We want to make sure the trustee does not disqualify the beneficiary from SSI benefits because that beneficiary would lose their Medicaid. Now, in the old days, before expanded Medicaid, what would that mean? Well, that was a life and death situation and still could be for someone. They lose their Medicaid, you are no longer here because they're overscale and they don't get underscale, they don't get rid of the excess money, or someone helps them and they kind of drift into oblivion as far as their Medicaid benefits. So this is not something to fool around with, as you know, and this is something we want to make sure our trustee is keenly aware of. Now, many of you are not aware, I find on a daily basis, you're not aware that if your child was disabled prior to age 22, if your child was disabled prior to age 22, they are a disabled adult child. And upon your retirement or death, they will no longer receive SSI, they will receive Social Security Disability. And now we're in that middle column. This is where many people are. They are receiving Social Security Disability based on their own work record or, as I just mentioned, their parents' work record because they are a disabled adult child prior to age 22. They receive Medicare as a consequence of that. And if their assets are low and they are on means-tested benefits, they will also receive Medicaid. Jeff, I think in the future we're going to need to include Medicaid here in the second column. Social Security Disability, Medicare, and Medicaid. So as we're going to see in a future slide, this disabled adult child benefit is very powerful, and it's one of the most important things to parents. Now, I'm not going to spend a lot of time today talking about qualifications for SSI. These are resources for you about the tests and the definitions. Here we see the $2,000 countable resource limit is still there. It's $3,000 for couple. I have actually seen a couple, 70-year-old couple on SSI, both of them, and they had less than $3,000. But generally, we are talking about an individual with less than $2,000. A home of any value is not counted, and an automobile of any value is not counted. So most people don't realize that a person with SSI, which is means tested, can still own a home. They can still own an automobile. 9 times out of 10, that's not going to be appropriate and the special needs trust would own the house or the automobile. Now, SSI, as we know in 2022, this is the benefit rate, thanks to Jeff putting this information in there. And in California and other places, there's a supplement. So remember, this is for food and shelter. As silly as some people may think about that, they think it should be a higher amount, but that's where we are right now in this world. We have to be aware of rules relating to unearned income and earned income. Now, to make a long story short, what these columns mean is that a person who receives SSI could, if they earn too much money, their SSI could be reduced to zero and they would lose their Medicaid. So we don't want that to happen. We have to be aware of how these rules work, which is beyond the scope of today's presentation, but I wanted to kind of start the process of you understanding that this is out there, and we can follow up on this in a future meeting, or you can read a book such as Kevin Urbash's book about educating yourself about this. Now, someone who's receiving SSI and they're living at home, they can have their SSI reduced by 1/3. Some of you are experiencing this, and that is a temporary thing that can be fixed. That can be fixed by making sure that the beneficiary is paying rent and so forth, which is a foreign concept to many of you. But what we don't want to do is lose this 1/3 if we could avoid it. So this 1/3 reduction is the maximum amount that they can reduce if someone is living at home and Social Security deems that they are getting food and shelter from another source. Now, let's say a person was living in an apartment and the Special Needs Trust was paying for that apartment. They weren't living at home and getting food and shelter. Then there would be still a 1/3 reduction because the trust is paying for their shelter. But the most that the trust could be reduced is the most that the SSI could be reduced is the 1/3. SSDI eligibility. I'm not going to spend a lot of time on this as far as the qualifications. Many of you are concerned about applying for SSDI, applying for SSI. I strongly encourage you to allow an attorney to represent you before Social Security so that you're positioned for any future appeals and so forth that hopefully won't have to be made, but could be necessary. Now, we just talked about the disabled adult child benefit. This slide illustrates that if you have a child or a loved one who is a child, I should say, who is disabled prior to age 22, they will switch from SSI to Social Security disability when you retire, and this means that they will receive 50% of the amount of the quantified amount that you're receiving. At your death, they will receive 75%. So they will no longer receive SSI. Most likely, they will just receive Social Security disability. And that is that middle column that I was showing you just a few minutes ago, which we'll go back to very briefly. This is where they are receiving Social Security disability, Medicare, and Medicaid. So those of you who will have a special needs trust, even though Social Security disability is not means tested, your loved one could have $1 million in the bank and still get Social Security disability. It's the person who is in the most cases, the person who is receiving SSDI, Medicare, and Medicaid because they are receiving a means tested benefit. So it doesn't matter whether the person is receiving SSI or SSDI. What's important is that they're receiving means tested benefits in either case, in most instances, not all, but in most instances. And the supplemental special needs trust is going to be implemented to protect their means tested benefits. Now, Medicaid covers certain things. I'm not going to spend a lot of time on that. You can review this yourself. Medicare covers certain things. We talked about housing. We talked about this being one of the greatest concerns, and a special needs trust can own a house. This is going to be a thing that most of you are going to consider, or if in the future the trustee of the special needs trust wanted to purchase a house, they could. For some of you, your loved one is going to live in group or other supported housing, and you're not going to be concerned about actually providing for a residence yourself. As I mentioned, HUD is harsh in its approach to a person with special needs receiving benefits from a special needs trust, and they will count that as income. However, there are ways to get around that by using an ABLE account, and hopefully we will be able to, in your particular situation, use an Achieving a Better Life Experience account to be able to deal with situations relating to HUD and avoiding how the rent would go up if distributions were made from a special needs trust directly to or for the benefit of the beneficiary. So housing is one of the biggest concerns that families have, and that is addressed in the special needs planning aspect. All right, Jeff, I'm going to stop again just to see if there are any questions, and I'm just going to take a drink and just pause for a second.
Thanks, Steve. We do have one question as of now, and that is, can a disabled person be on SSDI and then switch to SSI if they run out of money?
Well, thank you for that excellent question. My initial reaction to that question is that a person on Social Security disability is not going to be able to switch because they are on Social Security disability because of either their own work record or the work record of their parent. And if they are on Social Security disability because of either of those things, of course, then that will not stop. And generally speaking, the Social Security disability amount is higher than the SSI amount. Not always, but generally speaking, it's going to be usually a higher amount in my experience. So I don't think that it would be legally allowed to switch. And the practical side of it is, I don't think that it would be necessary to switch because the Social Security disability amount would continue on into the future unless the person had gainful employment, unless they had substantial gainful employment that showed they were no longer disabled. So I think I understand the concern of your question, but I don't think the person running out of assets would dictate a switch back to SSI, which normally would be something that would be a lesser amount per month. I hope that is helpful.
Okay, I think it is. Thank you, Steve. That's all for now.
Thank you, Jeff. All right, let's talk about special needs trusts now. Many of you are on this webinar today to talk about this. I'm just checking my time, and it looks like we are about 50 or 60% through the presentation. So thank you for your patience. Let's think in terms of two types of special needs trust, even though you're going to see three columns here. There's mainly two types. One is called the third-party type, the third-party supplemental needs trust, and the first-party special needs trust. So if you can easily visualize this, I hope, a third-party trust is the one that most families are going to implement. Why? Because the trust is funded with the assets of a third person. So if you look at this column, it says source of funds, anyone except the beneficiary. This could be a parent, grandparent, aunt or uncle, a sibling, friend. Someone decides at their passing to leave an IRA, life insurance, or other assets from their will or trust to the third-party supplemental needs trust. That means the money never goes to the person with disabilities, it goes to their trust. It does not go to them personally. So that means the money is never considered to be theirs, and therefore the money is exempt. It can be established by anyone. It's usually established by parents or grandparents or other loved ones. But the money that comes into that trust does not belong to the person with disabilities. So therefore, they are never disqualified for benefits. From benefits. And as you see here in the right column, it says upon that person's death, God forbid, the money is going to pass to whoever the grantor of the trust, whoever you say it goes to. So that is a third-party supplemental needs trust. And I will just say in estate planning and special needs planning, this is the bread and butter of what we're talking about. This is generally speaking what you're going to want to do. And this trust can be left inside of your will. Let's say you have a will, that trust can live right inside of it. Let's say that you're a person with a revocable living trust, which is nothing more than a substitute for a will. Well, the supplemental needs trust can live right inside there, or the supplemental needs trust can live on its own. It can stand on its own, and there are arguments in favor of that, that is the best way to go. That's the highest and best way to go. We'll talk about that a little bit more. Now, these last two columns are what we call first-party trusts. Instead of third-party trusts, they are first-party trusts. What does that mean? Well, that is lawyer speak for basically saying that a disabled person has money in their own name. They have money in their own name that they shouldn't have. Let's look at this middle column. Basically, a parent, grandparent, court, guardian, or the disabled person themselves can create this. Now, this is a new thing, a relatively new thing, where a competent or highly functional disabled person could create their own first-party special needs trust. But what is the circumstance? Well, we're going to see the circumstances that these first-party trusts are created. It means that the disabled person received funds from a source into their own name, not into the third-party trust, but into their own name, and that disqualifies them from benefits, and we need to do something about that. But you'll see in the right-hand column here that for the D4A type, which has to be established before age 65, or the pooled trust type, these trusts have paybacks. These are called payback trusts. They have to be paid back to the state of Maryland or any other state where the beneficiary was living, where they were receiving means-tested benefits. So you see that unless we have to, we don't use these first-party trusts unless we have to. And the third-party trust is really the bread and butter of estate planning and special needs planning. So as I just mentioned, the third-party trust is the best way of leaving an inheritance to a loved one, and it's because it is established by someone other than the person with disabilities. Now, you're very smart people for being on this call, and I know that you would never do this, but I just want to make sure that we are not making these mistakes. There are people, and you have seen them, and I have seen them, that will do these types of things, and we just don't want to. They say, well, I'm just going to leave my loved one an outright inheritance. Well, that's what we just talked about. We don't want to do that because that's going to destroy public benefits, going to lose SSI, going to lose Medicaid, and we're going to have to use a first-party trust. Now, a first-party trust can be used, that's not a problem, but the problem's going to be, it's going to be strictly regulated by the state of Maryland, and it's going to have a payback. So that's not a good plan. What if we left money in a non-qualifying trust? Now, this is going to be something that may be hard to believe today, but in the last 3 months, I have probably seen at least 3 or 4 trusts that are incorrectly drafted. They are supposed to be special needs trust or supplemental needs trust, but they are not drafted properly, or they're piecemeal drafted incorrectly. The person maybe didn't know what they were doing. The lawyer didn't know what they were doing. So that kind of trust can cause a loss of benefits. We don't want that. Some people will say, well, I'm just disinheriting my child and I'm going to leave it to my other child. Well, let me show you why that's not a good idea. That brother or sister or other loved one, what if they have creditors? The money could be lost to creditors. Bankruptcy creditors. What if they die and they didn't plan according to what you wanted? They left that to someone else, a spouse or other children, and those people say, sorry, it's my money. That's not a good plan. Maybe the child, and I see this all the time, and this is not a bad thing, it's just reality. What if the child or sibling does not want to take care of the one with disabilities? Many of you are blessed that you have a child who is just unbelievable. They're stellar, or maybe like I met a family the other day where there were 3 siblings supporting a very disabled adult child. This is amazing. These kids are amazing. But what if the person who's been tasked with this does not want to do it? Well, that's something that's going to cause an issue if you left the money to that person. What if the person you left money to got divorced? What if they had a tax issue? We don't want Uncle Sam taking the money. We don't want a divorcing spouse to take the money. So that's why we are using a special needs trust of some type to make sure that there is management for the loved one. So the third party trust, as we mentioned, the beneficiary doesn't create it. It doesn't hold any of the beneficiary's money. This is something we have to be careful about. And the trustee has discretion. This is a discretionary trust. This is not a support trust. So the state of Maryland is going to say, if it's a support trust, health, education, maintenance, and support, that's not a special needs trust. But if it's a discretionary trust where the trustee has sole discretion about supplementing or supplying distributions to or for the benefit of the disabled loved one, in their sole discretion for their special needs, and there's various standards that are put in these trusts, that is going to protect the special needs loved one and their benefits. So most families prefer this third-party trust. It can be revocable. There are no payback requirements to the state of Maryland. It can be drafted flexibly, with lots of flexibility, and this is, again, the preferred approach. It can be customized. Now, we've done entire webinars on this, and Jeff has access to our webinar library that he can make these kinds of things available to you, or you can go to our website to look at how to choose a trustee. But this is one of the biggest issues today. Almost every conversation I'm having with special needs families is who should be our trustee? And the question's going to be, should it be family members? Should it be professionals? Should it be attorneys? And the issues here are very specific to your situation. And there's no right answer for every single family, no same answer, I should say. So we want to make sure that the trust has flexibility and oversight. We want to make sure that if family members are going to be trustees, that they are educated. And we want to make sure that trustees are very cognizant of what their duties are, and that they're educated, and that they have the ability to serve, and that they have the willingness to serve. One of the biggest issues today is basically knowing that someone has the willingness to serve, and if they refuse to serve 10, 20, 30 years down the road, that there's enough flexibility in the trust to continue to choose new trustees and to keep the trust moving. So these are huge issues. At Elville and Associates, we have what we call our Waypoint fiduciary services, and we understand that there are a lot of families that are really on the fence about these issues, and we serve as trustees of many special needs trusts and supplemental needs trusts, and we are always willing and able to have a conversation with you about that. But also, we want to make sure that you're educated about all the choices that are available concerning corporate trustees, family member trustees, and of course, attorney trustees of all kinds. Now, what we're going to see in our example of a special needs trust is that it has contemporary features. So one of the contemporary features of a special needs trust is to basically talk to the trustee through the document. The document is just not a purely legal document, which most of them are. The document today can say, hey, trustee, you can hire professionals, you can hire advocates, you can have a committee of people if you need to call the psychiatrist and the social worker and the caseworker and the family doctor. If you need to call these people together, and relatives, you can form a committee if you're dealing with issues that you don't know how to resolve. We talked about the trust protector. We strongly recommend that you include a trust protector provision so that down the road, the trust has flexibility. The trust protector can remove and replace trustees, which I know is very scary to some of you, but you have to kind of take the time to think about this issue and get used to it. What if your loved one can't review their own accounting, which most special needs loved ones cannot? We want to make sure the trust protector has the authority to review accountings and to make changes to the trust if the trust actually needs to be changed. Many of you remember back in 2017 when the Congress was going to overhaul the Medicaid laws. I don't know if you remember that far back at this point, but it was a very scary thing for people in special needs community that Congress was going to revamp the whole Medicaid system across the country. So if that had happened, which it did not, but if that had happened, perhaps the trust protector would have had to make many changes to existing supplemental needs trusts. So these are just some examples that I'm throwing out there. Flexibility is key. Now, no supplemental needs trust or third-party trust is the same or should be the same, but these are many of the features of a modern trust. So we just talked about trustees and how important that is, trust protectors and how important they are, in my opinion. Maryland Able, if you have a child or loved one who is disabled prior to age 26, we know that they can have an ABLE account. Many of you have opened ABLE accounts for your loved ones. This is saying that the Special Needs Trust can actually fund or continue to fund an ABLE account. We talked about providing for advocates in the trust and reminding our trustees about what they can do. Memorandums of intent attached to the back of the trust. And if you use a Word program of some kind, you can update that memorandum of intent every 3 to 5 years or whenever you would like. The Trust Advisory Committee we just discussed, special retirement plan considerations. So many of you are aware, but some of you may not be, that Congress passed and President Trump signed in late 2019 the Secure Act. The Secure Act is not good for our normal, let's say, healthy, viable beneficiaries who have no disabilities. It's not good because they have to pay taxes in 10 years or less. And many of you now have heard of this now that I mentioned that 10-year issue. But people with special needs and disabilities and people with chronic illnesses are one of the handful of types of beneficiaries that are exempt from the Secure Act. So we want to make sure that our loved one with disabilities continues to be exempt, because when we leave IRA or 401k assets into a special needs trust, we want to make sure that that trust is exempt, and it's what is called an eligible designated beneficiary. We want to make sure the trust recognizes that the loved one with disabilities or chronic illness is an eligible designated beneficiary, and as a result of that is exempt from the Secure Act, and as a result of that, they can defer taxation on regular IRAs. They can, and 401ks, they can defer taxation as long as possible into their late 80s. And this is what we want. We want the special tax treatment that everyone used to get, but now only a handful of people get. We want to make sure the Special Needs Trust is optimized for that. These trustees are really great people. They understand all of these 3 concentric circles. They're good advocates. They're accountable and understand record keeping. They understand financial aspects of things. So let's just look at these bullet points. They have the best interest of the beneficiary in mind. They understand public benefits. Remember, I said most trustees don't. So we want to make sure they read the book or a book, and that they look at this webinar, let's say, and that person advocates for the best interest of the beneficiary and provides a great quality of life for that person as much as possible. But they comply with their duties. They have statutory duties of accountability. If someone wanted to look at the records, this trustee makes sure that every year there's an accounting. Okay, that's one of the trustee's main duties, the duty to account. We want to make sure the trustee is not investing the assets on their own unless they're a professional. So we want to make sure they're hiring professionals, that they understand taxes. They're filing tax returns every year, but they're investing the money in accordance with their fiduciary duty. And I know some of you are concerned about that. That is one of the trustee's duties. Now, what can a special needs trust pay for? Well, the third-party trust can pay for basically anything that's for the benefit of the beneficiary within reason, and it's very flexible, and there's no accounting to the state of Maryland. A first-party trust is more restricted. Jeff and I can send you a copy of expenditures from a special needs trust, what is allowed. So many of you throughout this presentation have heard me reference a supplemental needs trust versus a special needs trust. And many times I've used those terms interchangeably, but now I'm going to define it for you. So when we're talking about a third-party trust that's part of regular estate planning, we are calling that a third-party supplemental needs trust. But when we're talking about a first-party trust, the one that is approved by the government, the one that there's an accounting every year, and it shelters the benefits for the beneficiary who received those benefits those assets, I should say, that they had not received before, but now they have assets in their own name. Those assets have to be out of their name. We use a first-party trust. We call that, technically speaking, the special needs trust. So the third-party supplemental needs trust versus a special needs trust. Now, many of you have more than one child if you're a parent on this call, and you're going to deal with this issue of how do I fund the trust? Do I fund all the shares equally for my kids, or do I provide more for my special needs disabled child? Again, life insurance is a wonderful tool. I like to say it is the Swiss Army knife of estate planning. Work with your financial advisor. If you don't have one, help us understand that you don't, and we will help you get a financial advisor, get connected with one, or a life insurance specialist. Some of you have saved lots of retirement plan assets, and that's what you're planning to leave. I would encourage you to think in terms of, yes, you have those assets now, but will you have those assets in the future? So it's not a question of what you have now, it's a question of how much will you have at the time of your death to fund the trust. So that's going to be a financial advisory and CPA and attorney question, working in collaboration to determine how to fund the trust. As I mentioned, the first party trust is designed to take assets that the person was receiving themselves that disqualify for them for benefits and move those into a protected area. And that is the D4A type and the D4C type. Generally speaking, we are using the D4A type for someone who is under 65, but the D4C type can be used. This is a pooled trust, such as the Arc of Northern Virginia or Maryland First Disability Trust and other pooled trusts where there are, in certain circumstances, we believe that's appropriate. Again, the first party trust is most commonly used where someone's been injured in an accident or they've received an inheritance and so forth, that someone has left them money or they've received money that they should not have in their name. Now, you'll see here at the bottom that even though your loved one may not have assets in their own name, many times it's a highest and best practice to go ahead and get a first party trust approved by the Attorney General, which is not a very complicated thing. It sounds complicated, but we could help you get a first party trust approved, even though your loved one does not have assets in their name, so that that trust is already there should the loved one end up with assets in their name that they're not supposed to have. That first party trust is already created and it can receive those assets. And the first party trust is also used for military benefits. Some of you are retired veterans and you have a military pension. Well, thank goodness the federal government said that you can assign that to your first party trust for your child, and it will always be exempt. It will not cause their loss of benefits, and you can have the peace of mind of knowing that it's going to continue for them into the future, long-term future. All right, it's about 5 or 7 minutes after 11. I'm going to start towards the latter part of our presentation. So what is the process of starting special needs planning? Well, I apologize for this squiggly chart, but what this is really saying is that we at Elville & Associates believe in a process. We have very, very different processes or special processes for estate planning. It's all for educational purposes. And what we're doing here is simply showing you that we would take you through a series of meetings as a highest and best approach so that you have a process of how to do this, how to think about it, and we would simply lead you through a review and discussion until you felt comfortable. You've designed the special needs plan the way you want, you feel confident about it, It's been coordinated with other relatives who may be interested in leaving money if that's your situation. It's coordinated with your will or trust and your family members, and it is in order. So this is for the highest and best kind of planning, a process. And this is the process that we use. It's not something that we have to do for every single client, but this is what we recommend so that you are educated and your loved ones are educated. Now, we've talked about this a little bit. I won't spend a lot of time on this because I want to leave time for your questions. If your loved one needs guardianship, if they are over 18, then this is something that we want to address. But with supported decision making, guardianship may be avoided more easily because the state of Maryland and all states are supposed to consider all lesser restrictive alternatives to guardianship. And we want to make sure that happens. And fortunately, with supported decision making now in the law as of October 1st, this will be a mechanism by which courts will have to, and they're supposed to do it anyway, but they will have to consider all lesser restrictive alternative to guardianship. But if your child needs a guardianship, your loved one needs a guardianship, they need it. And then the question is going to be, can they have a supported decision maker as part of guardianship? If guardianship is not appropriate, then we want to have a high functioning person or a person with mental capacity with disabilities sign powers of attorney and advance directives, and hopefully still appoint a supported decision maker. There are two types of guardianship. Guardianship of the person, that's going to be the most common with special needs families, and guardianship of the estate. This is guardianship of the property, actually, where the person with disabilities actually has money in their own name. Or you wish to open an ABLE account for a person with high capacity, and I apologize, you wish to open an ABLE account for a person that does not have high mental capacity and actually needs a guardianship of their property. Now, Maryland supported decision making, I want to make sure that I spend at least a few minutes on this. We talked about this. I want to congratulate Megan Rusciano of Disability Rights Maryland, who I met many years ago at the ARC of Frederick. And Megan is a champion in her own right, and she deserves all the credit for having assembled a group and led a charge for the last several years, many years, leading up to the legislative session in 2022 and got the thing over the goal line. And now we have supported decision making in Maryland, fulfilling the mandate of the United Nations for human rights, and also putting Maryland on par with states like Alaska, Indiana, Wisconsin, the District of Columbia, Delaware, Indiana, and many other states with supported decision making. So congratulations to Megan. So remember, supported decision making is a tool. It's a tool. It can be a simple written agreement, or it can be verbal. Now, of course, it should be in a written agreement. Because the law just passed and it has not become law yet, we don't have agreements, but I'm almost 100% certain agreements will be forthcoming, and we at Elville and Associates are going to be creating our own agreement. Even if the legislature does not, we're going to create our own agreement in accordance with the law. So this is a whole new world, as I mentioned, of self-determination for people with disabilities. So as we kind of wrap up our presentation, I thank you for your attention. I want to encourage you to create a memorandum of intent. I want to encourage you to establish your own estate plan if you don't have one, or to revisit the old planning if you have an older plan. And I know many of you said you have an existing special needs trust. We want to review that and take a look at it. It doesn't take me long to review documents. We have 5 or 6 attorneys here and 2 special counsel attorneys here, and we have about 20 employees here at Elville and Associates in Columbia and throughout Central Maryland, and we are going to review any special needs plan that you have and make recommendations. We also want to make sure you have a financial advisor, or otherwise you're calculating the financial needs of your loved one. We also want to make sure that your special needs plan is optimized for the Secure Act and for retirement plan benefits. We want you to understand public benefits. We want your trustees to understand them. So your trustees are invited to come, subject to your discretion, to the meetings and learn. We have webinars, we have links that Jeff can send out. We want you to start thinking about who are the persons who will advocate for your loved one. If you don't have an advocate, we can introduce you to an advocate. We also, of course, want to encourage you that special needs planning does need to be part of your basic estate planning. Now, as I really wrap up, we want you to consider coming in to sit in one of our conference rooms and just have the time to think. We want you to know there's nothing to fear. We want you to complete an estate planning questionnaire, which is a little bit of work, but it's a process. We want you to know we have a process. We want you to participate in that process, and we want to have a partnership relation with you and your family. We want you to bring current estate planning documents for our review. It doesn't take us very long to review them, and we don't charge in most cases to review existing estate planning documents. If you don't have a financial and tax planning team, we want to help you have that team, including an advocate if you need one. We want you to prepare your questions. We love it when you come in with a list of questions. If you know what your goals are, if you know what your purpose is, we want to help understand that. If you don't know what your goals or purpose is, we want to help you develop that. And that's what this time to think, this time to have quiet time, which most families with special needs loved ones do not have. And this has been my experience over many years. So that's what our goal is. That's what we want to facilitate for you. So Jeff, with that said, it looks like we've ended on time here around 11:15. I've given some time for questions, and I know I covered a lot of material very quickly, but I wanted to make sure we got the supported decision-making material in, and I want to thank everybody for your commitment to education and for spending your time here on a very beautiful June day. And Jeff, I'm going to turn it back to you.
Well, thanks, Steve. Great presentation as always. This is always one of our most popular presentations, which is why we offer it at least once every quarter here at Elville and Associates. So let's look at our questions here. And now would be your time to get any questions that you have for Steve into me so I can get them over to him. Looks like we do have one question as of now. So the question is, Steve, can you distinguish the pros and cons of setting funds aside in an ABLE account versus a special needs trust?
Thank you for that wonderful question. So an ABLE account is exactly what it sounds like, achieving a better life experience account. What it's supposed to do what it does is it provides a vehicle for a person to have more choices. Usually a person that's a higher functioning disabled person, but doesn't have to be, because it's a nice vehicle to have tax deferred funds. Parents can get a tax benefit and so forth. And it's a tool. So for example, we talked about HUD being a problem. If someone pays or contributes money to their loved one who's living in HUD housing, it increases their rent because it's a distribution or it's income to them. But if that same person gives an ABLE account that money, contributes money to an ABLE account, and the ABLE account pays for those extra expenses for that loved one, it does not increase the rent. So ABLE is a tool. What I would do if I were you, I would look at ABLE as a tool. It is a tax-free tool. A person on SSI can have up to $100,000 in their account and does not destroy their SSI eligibility. A person that is not on SSI can have more than 100,000 or way up into the 500,000 range. So it's a wonderful tax-deferred tool, but it does not take the place of a special needs trust. The special needs trust, the supplemental needs trust is usually what we're talking about, is what I would say is the vehicle that creates a world. So we're creating a world for your loved one, and that world is to support your loved one to whatever extent you desire, to create a vehicle for their supplemental needs. Now, it can be used for more than just supplemental needs, but it needs to be in the discretion of the trustee. So we have the world of public benefits and whatever support your loved one has, but at your death, this is creating another world of support. So The ABLE account, of course, can only be funded up to $16,000 per year, whereas you could leave your entire estate and retirement plans, and other relatives could leave life insurance or whatever it might be into the third-party trust. So the third-party trust is an estate planning vehicle versus the ABLE being a tool to enhance the quality of life of a person with disabilities. I hope that helps.
It does. Thank you. And Kelly Nelson, the Outreach and Communications Manager with Maryland ABLE, is kind enough to let us use her slides for Maryland ABLE, which we don't have time to go through. But Steve, if you click through just another slide or two, you'll see the Maryland ABLE slides. And for our attendees, that is also included in the slides that I sent over to you earlier, which you're certainly welcome to look through. We also just had a Maryland ABLE webinar, which some of you may have been on, and I'll include in my follow-up email, which I always provide, a link to that webinar we offered last Wednesday, the 15th, as well as the full slides again from that presentation. I'll also include Kelly's contact information. She is a wonderful resource for anybody that has any questions about Maryland ABLE, and she's always been a great friend to the firm here. A few more questions have rolled in here, Steve. First one is our good friend, financial advisor Eric Edwards. Can a third-party trust agreement have multiple trustees?
Yes, thank you for that. Yes, so what we want to do ideally is plan for successor trustees, but it also could have multiple current co-trustees. So there's pros and cons to that, but yes, the answer is definitely yes.
Okay. And along those lines that you were just going towards, Steve, if multiple trustees, can they be set up as person A and person B working together, or person A or person B could be making decisions independently?
Yes, thank you. They could be set up either way, depending on the situation and what's appropriate. Absolutely.
Okay. Next one is, if a person has housing benefit, does it affect SSI?
Well, thank you for that. If I'm reading into your question correctly, if a person has, let's say, housing provided through medical assistance or other program, does it affect their SSI? And the answer is going to be no. That's not going to affect their means tested benefit, because that's a means tested benefit in and of itself, and it's not going to affect the means tested nature of the SSI.
Okay. Another one here, why age 26 as the cutoff for Maryland ABLE? What if over 26?
Yes, thank you for that. So we are asking ourselves that, and I think there has been much talk, I should say, and some legislation to try to increase that age. And I think this was something Congress came up with, and it seems to be an age they have set. And I'm not sure what the legislative history of it is, I'm sorry to say. Kelly Nelson seems to know more about this, I think, but there has been talk, I think, of increasing it to 46. I could be wrong about that, but nothing has happened yet. But I think that's a good question. Why isn't limited to age 26? And I don't have a good answer. I'm sorry.
Yeah, it is a good question, and Kelly said pretty much the same exact thing as you did, Steve, on the webinar the other day. They are working to get it increased, so that's where it stands. Okay, are there accounts like Maryland ABLE in other states?
The answer is yes. So Ohio, for example, was one of the first states that we became aware of here years ago when Maryland was really kind of contemplating how to implement ABLE. So yes, other states have ABLE, and to my knowledge, there are states that would allow an out-of-state person like someone in Maryland to create an ABLE account in that state, and I believe Ohio might be one of those. And then there are states that do not allow an out-of-state resident to create in their state.
And last one for now, can the disabled person contribute to their own ABLE account? An individual earned a pension from working.
And to my knowledge, the answer is yes. The only thing they cannot contribute to a special needs trust or to an able account, as I believe is direct SSI money or SSDI money, but other earnings can be contributed. And this is one of the ways that a parent can use, or the person with disabilities can use, an able account to keep themselves under scale.
Okay, very good. So those are all of our questions for now. If there's any more, please try to get them in. Pretty much right now, we're going to be wrapping up here in a minute here. While we're waiting for any final questions, I'll say I always try to provide a follow-up email with some good information for our attendees. I'll provide the video for today's presentation. You can share it with friends and family, with your financial advisor. I'll send the slides out again. I have several links to other presentations that are along the lines of special needs planning that might be helpful to you. I'll be sending out, and I'll be sure to get that email out very soon after today's presentation is over. As far as our webinar series goes, we're going to take a little break for a couple of weeks, and then we'll get back to it here in the middle of July. Tuesday, July 19th, we have our wellness series with Ms. Ellen Platt of the Option Group and Dr. Michelle Fritsch. Will be talking about social wellness on the 19th. On Wednesday, the 20th, Lindsay Moss, our senior principal here at Elville & Associates, will be discussing Medicaid long-term care asset protection planning. And on Friday, the 22nd, Steve alluded to trustee selection being its own presentation, and it actually is. We do it on a quarterly basis. And on the 22nd, we will be talking about trustee selection and how to choose the right one for you. So that's one that you certainly would want to tune into. So we look forward to hosting you for those webinars as part of our webinar series as we get back to it in July. Let's see if we have any further questions. And it looks like we don't. So Steve, thanks for your time. All of our attendees, thanks for your great questions and for being part of our webinar series. If you have any further questions, want to set a time to meet with Steve, feel free to reach out to me or his executive assistant, Mary Gay Kramer, and we look forward to working with you and being a resource to you. Thanks for your interest in Elville & Associates, and we'll see you again soon. Have a great day.
Thank you, everyone.